Hello, this is Robert Perkins, the immigration professor, and I want to welcome you to my video about same-sex marriage and the recent decision by the Supreme Court in United States versus Windsor case, which struck down a very controversial provision of law under the Defense of Marriage Act. You can see this is one in a series of many informational videos that we have on immigration topics. You can see all of our immigration videos on my website, which is www.immigration-professor.com. If you have a specific question on immigration issues, you can call our offices toll-free nationwide at 888-439-4560. So this was a very, very important step taken last week by the United States Supreme Court. Actually, the week before last, I should say, in a case called United States versus Windsor. I think in order to understand the implications a little better, I'll explain a little bit of the history of it. It used to be years ago that immigration would not recognize the same-sex marriage. Some of these marriages were legal in other countries, but as a matter of public policy, immigration didn't accept those. In 1996, Congress passed something called the Defense of Marriage Act, or DOMA, which basically defined marriage as between a man and a woman. So even though the society has progressed a lot since DOMA, DOMA was still the law for a long time. People tried to challenge it, and eventually somebody won a challenge to the law in the Windsor case. So what does this mean for immigration? It means quite a bit for immigration. First and foremost is the marriage petitions. Now, immigration has immediately announced that a marriage petition, which is an I-130, between a same-sex couple has the same rights as any other couple. So one may file a marriage petition, an I-130, for a same-sex marriage partner who is overseas, or if that person is in the United States, that person can potentially file and process for a green card with an I-130 and I-485 form. So that's one thing, is the person now can get a green card. I'll put equals green card through a same-sex marriage. The other piece of this that's interesting is immigration has been keeping a database since 2011 of petitions like this that were already filed, and they have stated that they're going to reopen these petitions on their own. So that's kind of interesting. The other interesting benefit is that the fiancé, the same-sex fiancé, they don't even have to be married, of a United States citizen, can now file a fiancé petition for the person they intend to marry overseas. It is required under the present law. Again, this is treated the same as a non-same-sex petition, and these, as long as they get married within 90 days of the fiancé entering into the United States, then the foreign national fiancé can adjust status based on the same-sex marriage. So that's a couple of other things. Another one, I'm going to grab my little notes to myself. There are immigration benefits for people that are, should be covered under the striking of this law. One of which, for example, what we call the derivatives of people, meaning the children under 21, in immigration petitions, automatically immigrate when the parent immigrates. So in this case, for example, let's say you have a same-sex partner and you've adopted some children, or they have some children of their own from a prior marriage or something else. Those children would also be allowed to immigrate with the foreign national. Another benefit, and again I'm consulting my notes, is might come in the context of defending deportation. There is a remedy to defend deportation called cancellation of removal, And we have done some videos of this on immigration-professor.com discussing the defense to deportation of cancellation. And in order to even try to qualify for cancellation, the person has to have a spouse, parent, or child who is a U.S. citizen or permanent resident. And so spouse, if it does indeed mean a same-sex spouse, which it appears to mean, someone may have the ability then to defend themselves against deportation proceedings based on cancellation due to a same-sex marriage. That's another benefit that comes into play with the Supreme Court's decision in the Windsor case. Again, I want to remind people that we have a series, a library of immigration videos on our website, which is www.immigration-professor.com. Or if you have a specific question about a case, you can contact us at our offices, 888-439-4560. We represent people all around the country. The last benefit that I want to mention here, there's probably others that I'm not even thinking of, is hardship waivers. And here's what I mean by this. There are people that have been illegally or unlawfully in the United States, for example. They may have the ability to immigrate through a petition, but they may have violated their status. Immigration can pardon or waive that with a showing of extreme and unusual hardship to a spouse or parent. So again, because spouse can mean a same-sex spouse, someone may be eligible for a waiver or pardon despite a violation of the immigration laws or some other laws, depending on what may have occurred. I would like to thank the person. I actually got a specific request to make this video online from one of the people that had seen some of the videos. I want to encourage all the people that are viewing me, if you have a topic you would like me to cover in this video, in these videos, I should say, please go ahead and email me or call me and let me know. I'm delighted to cover any topics that I haven't thought of that might be interesting to others. Again, you can see all of our videos on our website, www.immigration-professor.com. Thank you very much.